The Constitution was construed in your favor. The next case we want to talk about is Briars v. United States, 273 U.S. 28, 1927. This is a search and seizure case which sets constitutional standards which we talked about in the AM jur sections. I especially want you to pay attention to Note 3 here. Constitutional provisions for the security of a person and property are to be liberally construed, and it is the duty of the court to be watchful for the constitutional rights of the citizen and against any stealthy encroachment therein. When a federal officer participates with a state official in a search, so that in substance, and in effect it is their joint operation, the legality of the search and the use in evidence of the things seized is to be tested in federal prosecutions as it would be if the undertaking were exclusively the federal agent. The reality here is what they are setting is the standards must be liberally construed in favor of the citizen. It is the duty of the court to make sure that happens. So now, you have a right to be wrong. You have a right to enter your viable defenses that you honestly think. No state can turn that right into a privilege and issue a license and a fee, and if they do, you can ignore the license and fee. They must prove the burden of proof of willfulness, which they cannot do. If they do violate your rights, you do have a right to sue them. Owens v. City of Independence and Maine v. Thibautot. They have to give every consideration to you, and that's the way it is. The next case we want to talk about is Boyd v. United States 116 U.S. 616. The court is to protect against encroachment of constitutionality or security liberty. It is equivalent to a compulsory production of papers to make the non-production of them a confession of the allegations, which is pretended they will prove, and a lot of times that will happen in federal cases. They will claim. 20. Something they want to prove it. It has happened to me, believe me, and then the fact that they have claimed it makes it true. And then, of course, you have to prove a negative, which is impossible. Now, the seizure or compulsory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself. That is a violation of the Fifth Amendment, and in a prosecution for a crime, penalty, or forfeiture is equally within the prohibition of the Fifth Amendment. The bottom line here is Boyd protects against the encroachment of constitutionally secured liberties. It is arguing Fifth Amendment here, but it is basically arguing against encroachment. Another case you should know is Miranda v. Arizona, 384 U.S. 436, 1966. This is one of the most important things I am going to tell you. The Miranda decision is a heavy-duty case. Every American should know this case forward, backward, and inside out. Miranda. This is the one that says, you have the right to remain silent. You have a right to an attorney. You have the right to have your attorney present during questioning. Anything you say can and will be held against you on a court of law. If you can afford an attorney, one will be appointed for you by the court. Do you wish to make any statement on your behalf? And do you understand the rights I have spoken to you? As soon as they start talking to you, they are required to say that. If they don't say that, they screwed up. If they haul you into jail and they don't tell you this, read it to you, and then they want to make you sign a little statement that you know your rights and you knowingly waive them, please, folks, don't sign that statement. Use your head for something other than a hat rack. Do not sign that statement. Ever. You are knowingly waiving your constitutional rights. Don't ever do that. As soon as you hear those people talking like that, you tell them, I want an attorney. And I am not saying anything until I have an attorney. Especially if you are talking to federal people like BATF. These people will lie, cheat, and steal and do anything they can to hammer you. Their whole purpose in life is to hammer you. I don't want you to think, oh, what nice guys. Maybe we can work this out. Why don't we just talk and maybe we can get things worked out? You don't talk to these people, folks. When you talk to them, you will learn the hard way. Do not talk to these people ever. I don't care if you think you're a nice guy and you want to be courteous, if you think you're going to work it out, or if you think you can talk to them and you're smarter than them, I don't care. You don't talk to them. Period. 21. It is when you open your big mouth that you get in trouble. Not that you would do anything wrong anyway, but they twist, lie, cheat, and steal and make it into something you didn't do. And before you know it, you won't even recognize what has happened. I am telling you it has happened to me. Now, let us look at this Miranda decision. In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privileges must be observed. The person in custody must, prior to interrogation, be clearly informed that he has a right to remain silent, and that anything he says will be held against him in a court of law. He must be clearly informed that he has a right to consult with a lawyer and have a lawyer with him during interrogation. Do that, please. And that if he is indigent, a lawyer will be appointed to represent him. If he indicates prior to endearing questioning that he desires to remain silent, the questioning must cease. If he states he wants an attorney, the questioning must cease until an attorney is present. Where an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his constitutional counsel right. Test that theory, but I am telling you it works. I did it. Where the individual answers some questions during interrogation or custody interrogation, he does not waive his privilege and may invoke his right to remain silent thereafter. The warnings require that the waiver needed are in the absence of a fully effective equivalent prerequisite to the admission or admissibility of any statement, inculpability or exculpability made by the defendant. The limitations on the interrogation process required for the protection of the individual's constitutional rights should not cause an undue interference with the proper system of law enforcement, as demonstrated by the procedures of the FBI and the safeguards afforded to other jurisdiction. In each of these cases, statements were obtained under circumstances that did not meet constitutional standards for protection of the privilege of self-incrimination. There are 4 Miranda cases. That was the leading case. Then there is the Miranda warning case that actually locks down the steps of the warning, and then there is a Miranda interrogation case which locks in the standards for in-custody jail interrogations. Our next case is Norton v. Shelby County, 118 U.S. 425. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protections. It creates no office. It is in legal contemplation as inoperative as though it had never been passed.